So the defendants in the Manson versus Wood Gore case have struck back on Manson's request for limited discovery. Obviously, they opposed that, and so they filed that today, and they have some declarations and then arguments to the court on why discovery should not be allowed. So first up on that is a request by Gore for the court to take judicial notice of the proceedings that involved her and her sister regarding that restraining order. One of the things that Ashley Gore wants the court to notice is that the court, in the case of her sister versus her, dismissed the restraining order found against Brighton Gore, and the court said, the court made the following findings and orders. The court has read and considered all declarations submitted. The court takes judicial notice of all the declarations submitted by all the parties. The court finds insufficient evidence to support issuance of a restraining order in this matter. The request for restraining order is denied. The temporary restraining order is dissolved, and attorney's fees and costs are granted. So attorney's fees were awarded against Brighton Gore in favor of Ashley Gore. All the declarations that everybody wondered about, they're all now part of the court record in the Manson versus Wood case. So that's all there. The friends of Ashley Gore, the people who said that Brighton had engaged in some of the behavior that she had accused Ashley Gore of, that's all part of the record now. Believe it or don't believe it, again, now it's part of the record. I thought that was coming. Sean Hawley, who's one of the attorneys for Evan Rachel Wood, has filed a declaration. And she puts a lot of things in it, including news articles about Manson's behavior and allegations against him. But she also puts in some interesting information about discussions with the FBI. She says, in late 2020 and 2021, I had numerous communications with law enforcement agencies, including the LA County Sheriff's Department, the Los Angeles County District Attorney's Office, and the FBI regarding their ongoing criminal investigation of Brian Warner. In her role as attorney, she coordinated with the FBI and the Sheriff's Department for Miss Wood to provide testimony and other evidence in connection with those investigations. She attaches to her declaration email chain between her and FBI agent, among other things. So interesting to see them fight back on this. Now, I've only gone through these quickly, but again, I didn't see anybody try to defend this original FBI letter. Instead, they are defending the notion that there was an investigation, which I thought they would do that. So they also, both parties, Wood and Gore, file briefs with the court on why they don't think discovery should occur, or at least if it does occur, it should be a lot more targeted than what Manson is asking for. But of course, they would prefer it not to occur, making the general good argument that if defendants have to engage in discovery, what's the point of the anti-SLAPP motion? That's to prevent people from being harassed in lawsuits. Now, I've made the statement, which I still stand by, that since the lawsuit continues after this, that burden of having to attend to discovery prior to the hearing of the motion is not as high in this case as it would be in others. But still, they have a point, particularly if the discovery is too broad. If it is discovery allowed, there should be targeted to the allegations involved in the anti-SLAPP motions, I think. So let's look at what the general arguments are for Wood. She says there's no discovery available that would cure the claims around the FBI letter anyway, because she stands by her privilege claim that it was part of the custody proceeding and she has privilege for documents that were filed in relation to that. She says as well, these Ashley Smithline Instagram messages we've all seen, that whether they're true or not, they're inadmissible hearsay. And I think Sean Hawley also mentioned in her affidavit or declaration that there was another conversation that contradicted that. Her point being, who really knows what anybody said in these DMs at this point? And given there's hearsay on hearsay, that's a valid point against those things. She is also asking the court to say, listen, even if we did these recruitment activities that Manson alleges, those things are not extreme and outrageous conduct. So what's the point of having discovery on it? It doesn't rise to the level of intentional infliction of emotional distress anyway. Discovery is not going to change that. So absent evidence of outrageous conduct, the plaintiff shouldn't be entitled to discovery on other elements of his claim. If you can't meet that prong of the claim, if you don't have something for that, there's no point fishing around for things that would support other things. A logical argument. And then she makes the claim, which I see, that Wood's liability on defamation, that's fatally deficient. There's no evidence to suggest that Wood herself made these claims that are defamatory about the groupie video. Nothing in evidence at this point. Let's slide over to Gore's brief, which also opposes the discovery. And you see that she's saying that the plaintiff misstates the high burden necessary to secure discovery. Of course, they would, because they want the discovery. Likewise, the defendants are going to overstate that. But they make a very good point, which is you can't just go around giving routinely discovery for anti-SLAPP hearings, because the statute stays discovery. So if it was going to be happening all the time, which every plaintiff would want it, why would you even bother having it in the statute? It's a very fair point. And again, I think what's material here is that the lawsuit would continue even if they succeed in anti-SLAPP. I think that makes a difference. It does to me. I don't know if it will to the judge or not. And she says that regardless, that there's not good cause shown for requested discovery for the groupie video comments, and that there's not good cause shown for discovery for defendants' communications with plaintiffs' accusers, or anything to do with the FBI letter, particularly for Gore, because she says, hey, why should I have to be involved in discovery with this FBI letter? I didn't make it a part of the anti-SLAPP motion, so just leave me out of it. That's an okay argument, except if the judge wants to grant limited discovery to anybody other than the party directly involved, yeah, she's going to have to answer for this. But credit to the lawyer for making the argument anyway. Let's slide back over to Wood's brief. In the opening, she says, plaintiff admits he filed this lawsuit without sufficient evidence to make a prima facie showing of his claims. And they I see what they're saying there. They're saying that if he needs a discovery, he didn't have enough evidence when he filed the lawsuit. Yeah, that's a good point. That is why, to try to show that his claims have merit, plaintiff seeks an unprecedented 5 depositions on numerous issues, including publication, falsity, extreme and outrageous conduct, conspiracy, intent, and actual malice. If granted, plaintiff's request for wide-ranging discovery, including unbounded depositions of both defendants, would subvert the very purpose of the anti-SLAPP statute. Where a defendant like Wood is being sued for engaging in protected activity, discovery is barred unless the plaintiff can demonstrate good cause, and even then, discovery should be limited by time and scope to only what is absolutely necessary. So her point is, he's trying to do discovery on every element of everything he's talking about. If he was that ill-prepared with evidence when he was bringing this claim, knowing the nature of the anti-SLAPP statute, then he shouldn't have brought the lawsuit. He's not entitled under the statute to go around curing all of his defects just by engaging in all kinds of discovery to figure it out. That's a great argument. And again, I fully agree with that. If discovery is allowed, and I've told you why I think maybe limited discovery should be, I agree with their point that it has to be limited in scope. It really does at this point, to the bare minimum necessary to address certain things relative to the anti-SLAPP motions. But defendants have a good point too, of course, which is you brought the lawsuit, you know what the rules are, and the rule isn't you just get to do discovery to figure stuff out. You made the allegations. You knew when you filed the lawsuit that you were supposed to have available to the court enough evidence to show a prima facie case to move forward, and you can't depend on discovery to do that. So by saying you need all this discovery, you're essentially admitting that your lawsuit didn't have the requisite merit by evidence at the time that you filed it. It's a very solid argument. It's a very solid argument. So now we have this stuff in front of the court. We have the defendant's positions on this, which is obviously don't do the discovery. That violates the whole point of the anti-SLAPP statute. Let this dude make his case or not make it. So I think in a case like this where where discovery is frozen, but it's up to the discretion of the judge to allow some discovery, there's really no way to call this at this point. The judge is going to have to decide whether the judge thinks that the anti-SLAPP is really serious, that discovery is only the rarest instance on a very narrow thing, and by Manson asking for so much discovery, okay, that no, you need to make your case. Now, on Manson's side, his attorneys listed for each person that they wanted to depose the specific things that they thought they would find out that would support their lawsuit. And that is a kind of targeted discovery. I don't think there was any proposed order that they wouldn't ask for things outside of those limits, so I see the defendant's arguments here. But also in doing it, the defendants make the point that this is so many things he wants discovery for that this is completely against the whole concept of the anti-SLAPP. If Manson had come forward and said, I need discovery on just this one thing, because they have that and have lots of evidence on all these other things, their argument would be weaker. They're saying the generality of his request, that I need some of this, I need some of that, mean that he has failed in his essential burden to have the evidence necessary to move his complaint forward, and discovery is not meant to cure that here. Okay, that's what the anti-SLAPP is for. Otherwise, why would you even have it? You just have motions for summary judgment after everybody does discovery. So solid arguments by Manson's team to start with, and good evidence that they've thrown up. The defendants have put the law into play here, and some facts on on these declarations that they filed I don't think they're really overwhelming or to counter Manson's arguments, showing that Bright and Gore may have some credibility issues or motivation issues, as we've discussed earlier. I didn't see anything new on that. That's important, I suppose, to understand the concept of how, where, and where she's coming from. I don't think it changes a lot at this posture of the case. And Sean Hawley's stuff, showing about the investigations and things, it's important to get their side of the story start to come out a little bit. Some of the stories about how Manson may have threatened her, how she was in contact with the FBI, that there are facts behind that. Let's get some of this PR machine working for the defendants a little bit. Not sure that it matters so much for the legal arguments about the anti-SLAPP motion itself and the discovery for that. I think that's better covered in the brief. I do note one thing was stated in the brief is that the iPad that Bright and Gore accessed was allegedly done so without the consent and knowledge of Ashley Gore. I thought they might say that. What that does seem to indicate, however, is it probably was her iPad, because else why would she need her consent and knowledge to look at an iPad that wasn't hers to begin with? They could have just said there was no such iPad. So to me, the FBI letter, it gets even weaker as you move through this, because there's nobody standing up to defend it. And now the iPad looks a little more real than some people who have questioned it maybe thought. I thought for sure this iPad is real. I don't know if everything on it is real, but that story added up to me that Brighton told. What they've said here about Brighton's credibility, I do agree to take that on board when she talks about stuff about Ashley, but it doesn't change the facts of what was on the iPad as long as that stuff is found to be valid. So we're getting closer to when the judge has to take this up and make the decision. It's anybody's call how this turns out. I wanted to give you a quick look at it. Thanks, bye.